Hello, I'm Stacey Nichols from Neuberger Rose. Thank you for joining us at Neuberger Rose Online. I'm joined today by my partners, David Rose and Joseph Neuberger, and we're going to be talking about the seizure of property by police. We've heard lots of stories, Joe, in the news about police seizing property such as cars and homes. Can they do that?
Oh yeah, and they do it often. It typically occurs with 2 or 3 types of common cases. Cases involving drug transactions, which involve somebody's home, like typically a grow operation. These can be instances where individuals are growing small amounts for medicinal purpose, but they don't have their authorizations. But any sort of drug transaction which occurs at a residence, the home is liable to be seized. Drug transactions which occur, for example, with a car, where somebody's traveling to some location to purchase something. The individual could be charged with conspiracy to commit an indictable offense and have their vehicle seized, have their property seized at the same time. Larger drug transactions, which are conspiracies, people's bank accounts and assets can be seized. And then fraud, which is the other very typical area where an individual who may be alleged to be involved in a fraud transaction or a series of fraudulent transactions can see almost every asset they own being frozen, which would include homes, boats, cars, jewelry, and all their money, so that their bank accounts are completely frozen.
Thank you. David, once your property's been seized, is there anything you can do?
Well, there's a variety of things. And it really comes about 2 different ways. These forfeiture provisions can apply to someone, for instance, if they're the owner of property and someone else has done something to have them seized. So consider a husband and wife, and one of them has done something to get themselves arrested, but the property is actually owned by the other spouse. And the other spouse, who has nothing to do with this, was never arrested, may have their property seized, whether it be a car, or a home, or a bank account, or something like that. And those people absolutely have remedies under the criminal code for forfeiture, relief for forfeiture, as we call it. The other thing is that people who are charged themselves may have some remedy. They may have an ability to have, by application to the court, to have that property freed up for various reasons, either before, during, or after trial. Or they might have an ability to have some of the value in it released to pay legal fees. So there are a variety of remedies that can be done under the criminal code.
Thank you. Joe, I know you touched on this, but are there any particular types of offenses that are more likely to attract these types of seizures by police?
There are, and I think there's a couple aspects we should talk about. It's very common with drug cases and very common with fraud cases. And so in those 2 instances, the government typically uses seizure orders or restraining orders on property to try and combat the individuals who they think are committing these crimes. And so they often use them in those 2 areas. And it's extremely important for a person who is facing these type of allegations to act proactively. It is not simply where they should just sort of wait to see what happens, because in many instances, particularly if we're dealing with people's homes that they own, when the police bring the restraint order, this is done without notice, as we call in the legal business, ex parte. So the individual who owns the residence who's accused of this offense does not receive notice until they get something in the mail that says your property has been restrained. And typically they're notifying the bank. So if somebody has a mortgage on their house, the bank's already been notified under the restraint order, and they've already taken steps to cancel the financing on it. And so it's very important for people to act proactively. And we have a case that we're doing right now where we have to actually apply to court, and we're bringing a relief application just to put in place new financing to sustain the property from being sold. And these are very, very effective methods which are used by police, and they can have crushing impacts on people. And it's extremely important for an individual facing these charges and who's got a restraint of property to act proactively.
Right. David, any idea how often the seizure of property actually results in forfeiture of the property?
Well, sometimes. If they're not properly defended, that's absolutely what can happen. And I think from the client's perspective, they have to, as Joe said, be very proactive. They'd be prepared to file an application to either restore the property to the owner or to somehow vary the terms of it so that it's not as harsh, the consequences aren't as bad to the owner. So again, that's something that we can do at the very beginning. We can do it during the course of the trial, and at the very end, it will be up to a court to order forfeiture or not. And so that's where we come into play and make representations to the court to either fend it off completely or vary it on terms which are advantageous to the client.
Thank you. Thank you very much for joining us at Neuberger Rose Online. If you have a question about this or any other criminal law topic, please visit our website at www.nrlawyers.com. Thank you.